that night. He got in his car. He knew it was nighttime on August 28, 2013. You see it in the video. The lights are not on. And we're not talking headlights, we're talking taillights. And if his taillights weren't on, nobody would be flashing forward lights at him. And here's the clincher. The judge will instruct you that the state does not have to establish that Mr. Budenholzer knew those taillights were out. Mr. Hawkins spent a great deal of time on this. Oh, he didn't know, the valet turned it off. We had the valet come in and testify that generally people will turn off the lights. But Mr. Hernandez, the valet director who came to testify, couldn't tell you whether Mr. Budenholzer's lights were on or off. He couldn't tell you what time Mr. Budenholzer picked up the car that day. He couldn't even guarantee that the lights actually were turned off. He also indicated to you that any adjustments that the valets make to cars, it's the responsibility of the driver to make any further adjustments because they know their cars. Mr. Budenholzer admitted he knows. At night, you put your lights on when you drive. You need tail lights, you need headlights. But again, the important thing is here, he intended to drive that car on that night, and the car did not have its taillights on. You see it in the video clip. Those lights are not illuminated. Defective or no taillights at the time he was driving that vehicle. That brings us to the next charge, the DUI less safe. And as the judge will instruct you, the DUI less safe is a charge that is different than what many people think of as DUI, or drunk driving as some people refer to it. The law is going to be explained to you, but what the state has to establish is that Mr. Budenholzer is less safe behind the wheel of the car that night than if he were not affected by alcohol. That's what we have to establish, that he was less safe. Now, less safe could be less efficient, and you'll be instructed on this by the judge. Less skillful, less coherent, less able, less qualified, or less proficient. So all of the investigation that's going to take place with Trooper Nelms and Mr. Budenholzer on the side of the road during that relevant time is to assess whether he is a less safe driver. Now, in order to determine that, Trooper Nelms, a member of the DUI task force, an officer who had done DUI arrests and had DUI training prior to coming into the task force, explained to you that when he went through his intensive training to become a member of the Nighthawks of the GSP, they went through three phases of the DUI investigation. So my hope is to kind of guide you through the evidence here based upon those three stages and help keep it all together. The first stage, it was the vehicle in motion. If you recall, Trooper Nelms said one of the phases that they look at is the vehicle in motion. Are there any less safe acts? Are there any moving violations? Well, first of all, ladies and gentlemen, the state doesn't necessarily have to prove a less safe act, and you'll be instructed on the law on that. You do not actually have to wait for the officer to see a less safe act. He testified here. You don't have to wait until there's an accident or until someone is harmed or until someone does something wrong, because the purpose is to keep the roads safe. So they can be preemptive when they determine someone is less safe. Trooper Nelms did admit to you that initially when he sees the vehicle in motion, his first thought wasn't this person is DUI. He explained part of his job is to uphold the laws of Georgia, including the traffic laws. And he witnessed, as you see in the picture there, a violation. So he pulled him over, and then that is when he first begins his DUI investigation. Now, Mr. Hawkins made a big deal up here with all the witnesses, in particular Trooper Nelms, about you didn't see him commit any traffic infractions. You didn't see him commit any moving violations. You didn't see him commit any less safe acts. Ladies and gentlemen, regardless of how well a street is lit, driving without your headlights or taillights is less safe. So let's move on to the moving violations. Trooper Nelms was honest with you. On the night of the incident, he was noticing the lights and did not necessarily indicate any other moving violations. But when he was pushed on the stand to give testimony that there were 0 moving violations, he could not tell you a lie, because in reviewing his video, and he admitted that this is when he noticed it, he saw other traffic violations. He stated that Mr. Budenholzer took a right turn from the left-hand lane. And Mr. Hawkins said, no, no, no. Didn't he pull into the right lane? He put his blinker on like a good driver, pulled into the right lane, and then made a right turn. And Trooper Nelms said, that's not what I saw. Now, ladies and gentlemen, the video speaks for itself here. I want you to notice right here, in the middle of this street, where the right turn is being made, the tires are on the left side of the street. And when you get a chance to watch that video again, which I'm sure that you will, you are going to see there was not a complete switch into the right lane. In fact, Trooper Nelms told the truth. He started his turn in the left lane to make that right turn. That's a moving violation. Trooper Nelms also said he parked really close to the curb, almost to the extent he might have damaged his new car. Oh, where did you see that? That wasn't in there. He parked perfectly. Ladies and gentlemen, that tire is right up on that curb. The video speaks for itself. Trooper Nelms told you what he saw, and he admitted those were not factors he took into his initial investigation, but that is in evidence. Mr. Hawkins tried to get him to say there wasn't a single traffic violation. And keep in mind, Trooper Nelms was only behind Mr. Budenholzer for approximately 30 seconds. He testified today that he was at West Paces Ferry where his car got dropped off. Mr. Ferry testified that's approximately a 10 to 15 minute drive. 10 to 15 minutes, including going on the highway with no taillights on. And no one here can testify as to whether he did or did not have any driving infractions at that point. So again, I draw you back to the time period at hand that we know about, that we can see on the video, the relevant time period. So Trooper Nelms stops Mr. Budenholzer to tell him it's less safe for him to be driving without his lights on, to figure out what's going on. Then began phase 2, the personal contact. Trooper Nelms testified there are a number of cues and clues that they look for during this, but he also testified that every DUI investigation is different, and not all the cues are going to be visible in each investigation. So he readily admitted Mr. Budenholzer didn't seem to be fumbling with his license. gave him the license. He said he didn't seem to see any problems with him being able to understand what was happening, but he did notice two things. He noticed red eyes and an odor of alcohol. And those are two cues which in his training and experience could be indicators of impairment. So as part of his job, it was his duty to further that investigation and verify. You even hear him on the video. I got to make sure you're not impaired. If you're not impaired, you'll be on your way. He has to do his job. So let's talk about these red eyes. Blepharoconjunctivitis. We had a doctor come in all the way from San Antonio to tell us about blepharoconjunctivitis. We have a very bright picture here of blepharoconjunctivitis, supposedly. Do we know when this was taken? Was it taken after the playoffs? Was it taken when he was tired? Was it taken after he had alcohol? Who knows? What we do know is that Trooper Nelms testified that the way Mr. Budenholzer's eyes look in this courtroom today is not the red eye condition that he noticed then. So what did Dr. Rashid say? He said in 13 years, he had seen Mr. Budenholzer 4 times. 4 times. For a condition that he made out to be a pretty devastating one for most people. People being falsely accused of drinking. He has to write letters to people's jobs because they get so falsely accused for drinking. A condition that he made very clear Mr. Budenholzer knows about, that he recommended treatment for. And Mr. Budenholzer even admitted he knows about those treatments, but he hasn't done them. But they're difficult treatments. Putting a Q-tip in your eye does not sound like something easily forgotten. A red eye condition, when an officer is telling you you're under suspicion of DUI because your eyes are red, this is not a condition you forget to mention. This is not a condition that you say, I don't know, my eyes are always red. My wife thinks I may have allergies. You shout it from the hilltops and say, I have a red eye condition. That's what's causing this. People have been accused of being under the influence because of it. And he completely forgets to mention it. Now he says it was a stressful situation. Ladies and gentlemen, being the head coach of an NBA team is a stressful situation, whether it's in the playoffs or whether it's in the first season game. This man knows how to handle stress, and he does it well. We've all seen him handle it on TV, in press conferences, being asked difficult questions about what happened in the game that didn't go well. We've seen him on the sidelines handling pressure situations, talking to his players. This man knows how to handle stress. And quite honestly, if you watch the video, he doesn't seem stressed about the eye condition. That eye condition, ladies and gentlemen, that witness who came in to talk about that, told you nothing of any relevance that would have changed Trooper Nelms' decision. Trooper Nelms even said it wasn't just the red eyes. If this whole case hinged on the red eyes, maybe. But ladies and gentlemen, that was one cue in a whole series of events. And we'll get to some of the other stuff that Dr. Rashid said in just a moment. But I do want to show you. These are a couple of pictures of Mr. Budenholzer. Not quite as red, a little bit red. There, it's not nearly as bad. And again, I don't contest, I don't say that these happened on that particular night, but I want you to be aware his condition varies. And the doctor himself admitted that alcohol would worsen the condition and make it more obvious. And that's what Trooper Nelms saw that night. The other key that he noticed was the odor of alcohol. Smelled a strong odor of alcohol. Said, all right, get out of the car. He wants to make sure it's just not something in the car. Maybe the valet was drinking. Left the odor of alcohol in there. So Mr. Budenholzer, will you step out? And if you notice in the video, he's up close to him. Not 4 to 5 feet away. He's up close to him, listening to him talk. And he still smells that strong odor of alcohol. Another cue that this might be an impairment situation. So he asks, Mr. Budenholzer, have you had any alcohol tonight? And he admits, yes. Ladies and gentlemen, how much does he say he had? 1 glass of wine. Trooper Nelms even starts asking him, oh, well, when was your first glass of wine? My first glass of wine and my last glass of wine, I only had 1 glass of wine. No, well, when was your last? The first glass was the last glass. 1 glass of wine. He admitted here that throughout any interactions with Trooper Nelms, 1 glass of wine. But the waiter who came in, Mr. Kavanaugh, how much alcohol was served? About 2 glasses a person. How many glasses of wine? 4. How many people were drinking that wine? 2. Mr. Berry testified, they had a glass of wine, got a second glass of wine. Mr. Budenholzer drank half. He had left half to 1/3 of that wine in there, meaning he had drank at least a glass and a half, if not more. Now here we are 3 years later, and Mr. Ferry can remember exactly how much wine, more or less, was drunk that night. And 15 minutes after he'd had that glass and a half, if not more, Mr. Budenholzer couldn't. Ladies and gentlemen, I submit to you, he was concerned if he said he had any more than a glass of wine, that was going to affect the investigation differently. Even here, he admitted on this stand that he had more than a glass of wine. So why did he only say 1? Why did he hide the fact he had more than 1? We'll get back to that. The next phase of the investigation is the pre-arrest screening. Trooper Nelms testified to the training that he went through, a 24-hour set of training on field sobriety tests. He had people come in that were dosed with different levels of alcohol. They had to pass certain standards, meet certain standards to figure out whether they were doing it correctly. And yes, he practiced the field sobrieties. But ladies and gentlemen, he practiced giving the field sobrieties, not taking them. His practice wasn't to see how well you can walk. His practice was to see that he followed the rules in terms of giving those instructions. So don't be fooled when Mr. Hawkins talks about, oh, Coach Budenholzer, you weren't allowed to practice that test. And Trooper Nelms was. Trooper Nelms' practice was on how to administer the test. Did he say the right things? Did he do the right things? Did he demonstrate it correctly? So he talks about each of these tests, and we'll just go through them a little bit one by one. We already have an admission of alcohol. That is then continued the investigation. Now we have a lot of testimony about he wasn't drunk, he wasn't stumbling, he didn't get out of the car badly. We heard testimony today, he didn't seem drunk. Ladies and gentlemen, the standard for a DUI less safe, as the judge will instruct you today, is not whether he was drunk. We do not have to establish someone was drunk to establish that they were a less safe driver because of the alcohol in their system. Don't get fooled by that. There's a lot of words being thrown around here, a lot of distractions being thrown your way to pull you away from this pre-arrest screening section in particular. And why is that? Because of the field sobriety evaluations. You'll notice not a lot was said by Mr. Hawkins about these field sobriety evaluations. Talking about the slurred speech, talking about the red eyes, talking about driving around all day with Mr. Ferry. But nothing was said about why those field sobriety evaluations look like they do. And that, again, is the relevant time. That is when Trooper Nelms was assessing Mr. Budenholzer's ability to drive at that time that he had just been behind the wheel. The first one he talks about is the HGN, the horizontal gaze nystagmus. And Trooper Nelms described that as when you're watching the eyes and doing the number of tests, it's like a windshield wiper on a dry windshield. So it just skips a little bit, as opposed to smooth, as windshield wipers would be on a wet windshield. Now, the judge will instruct you that the horizontal gaze nystagmus can be caused by the ingestion of alcohol, and you heard Trooper Nelms testify to that. Depressants is one of the things that cause nystagmus, HGN, excuse me. And alcohol is a depressant. When accompanied with the odor of alcohol and the admission of alcohol, Trooper Nelms presumes that results there, that is what he's looking for. He's trying to assess alcohol at this point. The judge will instruct you, this is a verifiable process. It's used in many places. There is a science to it. Even Dr. Rashid talked about it. That yes, those aren't the most ideal conditions when you're outside in the dark, but he even said the officers don't get the ideal conditions. What did he tell you was the ideal way to spot nystagmus? With a machine. And he told you that Mr. Budenholzer has resting, at first he said resting HGN, horizontal gaze nystagmus. And I asked him to clarify. Remember I said, well, aren't there different types of nystagmus? And are you saying he has resting nystagmus or resting HGN? And he stumbled over his answer. He had diagnosed it once. Did he diagnose it with a machine? It's easier to see that way. The most important question I asked him was, will alcohol increase the effects of even any resting HGN or nystagmus? And he said yes. Now that nystagmus, we talked to Trooper Nelms about the procedure he used, and he explained to you that one of the parts of that procedure is he does have to medically qualify the person who he is doing the HGN on. If he notes that there's nystagmus or any uneven pupils, etc., that would affect that test, he said he would not conduct it. He didn't see any of that. There was no mention of resting nystagmus by Mr. Budenholzer. And what were the results of that HGN test? 6 of 6 clues. You might even notice that at times in the video, Trooper Nelms had to say, my stimulus is over here, my finger's over here, because he was no longer looking at that.
Excuse me, Ms. Batras. Your Honor, may we approach?
Yes.
You know what? Let me just ask the jurors to step out for just a second. Jury. There was no discussion at the start of this about the amount of time for closing argument. Because of the length of this trial and the amount of witnesses that were called, my assumption, which I guess I should discuss with you both, was that you would each take up to an hour. My understanding of the rules are that we have, as a judge, I have enormous leeway in this. I guess it should have been discussed ahead of time. It was not. So I'm going to, whatever time the state takes, obviously, Mr. Hawkins, you'll get that much time. She should start exactly at 1:07, according to my calculations. So you may want to move it along, and but certainly any amount of time she gets, she'll be able to get an equal amount of time.
We just make my record, Your Honor.
Yes.
My understanding, unless there's been a rule change that I'm not aware of, is that closing arguments are limited to 30 minutes for each side unless a special request is made prior to closing an argument. We asked to approach when the state's prosecutor went beyond the 30-minute mark. There's been no request, either on or off the record, to extend the time past 30 minutes. We would object to the state continuing past the 30 minutes. I acknowledge that Your Honor has discretion on this. I would ask you to exercise that discretion and recognize that in the absence of a specific request prior to closing arguments beginning, that request for additional closing argument be denied.
And again, you made your record. I just, again, because of the amount of time this trial has taken, the amount of witnesses we've had, we're almost here a week now. In my mind, an hour was appropriate for each side, and I guess I should discuss that with everyone. Whatever time the state gets, certainly the defense would also be able to get. Okay. You can bring back in.
Judge, I just, before you bring the jury in, Ms. Battress has indicated that she gets to rebut, that she is reserving her rebuttal. The defense is not given that same opportunity, Your Honor. So this has created an inherent environment of unfairness that she gets to use more than 30 minutes on her initial part, which is the time allotted for the entirety of the state's closing argument. Yet we are going to be given an amount of time without the opportunity to rebut. So we would object to that on that basis and ask the court to reconsider exercising the court's discretion.
Your Honor, the state has the burden and therefore is allowed that time. You said an hour. I am happy to reserve a portion of that hour for my rebuttal and still stay within the hour that you have assigned to both parties.
Okay. Duly noted.
Your Honor, if I might.
Yes.
17-8 to 74 actually says shall not exceed 30 minutes. Misdemeanor cases brought on inferior judicatories, which is non-felonies, shall not exceed 30 minutes. I would ask the court to read the statute and enforce the statute.
I'm sorry, 17.
874.
And that's probably not, the rules are probably different. Let me just take a minute.
Your Honor, if I may just briefly.
Yes.
There has been a number of time concessions here and statements made that that the state's witnesses needed to complete their testimony within certain time restrictions, and the state would ask that the closing arguments be allowed to assess the fact that there were, I believe, 7 total witnesses here. This is an unusual misdemeanor case at the least.
Judge, here's the rule.
Sorry, I'm going to read it.
Sorry, not the rule, I should say the law, the statute.
I'll be back. You can take that down. Give me just a minute.
You can take that down, she said.
Yes.